Good afternoon. I'm Becki Young, a partner and business immigration attorney with Grossman, Young & Hammond. Our goal in this video is to bring to your attention some imminent changes to the H-1B visa program, provide some details on how these may affect you and how you can prepare. We must point out that this short presentation is for informational purposes only and does not constitute legal advice. For legal advice, you must contact an immigration attorney. In recent months, there has been a flurry of drastic and dubiously lawful rulemaking relating to H-1B specialty occupation visas. 2 have come from USCIS and 1 from the Department of Labor. Individually and cumulatively, these changes would render the H-1B visa program unrecognizable to the way it has been for decades. This visa will discuss the Notice of Proposed Rulemaking from the USCIS entitled Modification of Registration Requirement for Petitioners Seeking to File cap-subject H-1B Petitions. I'm here with Khandi Sokoni, counsel for the firm, who has extensive experience with H-1B visas and will discuss the proposed changes. Good afternoon, Khandi.
Good afternoon, Becki.
Before you guide us through the substance of the proposed rule, let me provide some background. The rule was published on November 2nd and is currently in the standard regulatory commenting process that's set to end on December 2nd. After the comment period closes, USCIS must consider the comments and either revise the rule or explain why revisions will not be made. USCIS publishes the final version of the rule along with the effective date. Typically, this is no less than 30 days from the date of publication of the final rule, but there are exceptions, and the Trump administration has a record of bypassing the standard rulemaking process. In short, it's a proposed rule that the administration is trying to push through before President-elect Biden takes office on January 20th. If implemented, its future under a Biden administration is unclear. So, Khandi, why don't you give our viewers a brief summary of the current H-1B selection process?
Thank you, Becki, for that background. As many people know, the H-1B specialty occupation visa category is subject to a quota system with 65,000 visas available each year, plus an additional 20,000 visas available to those who have a U.S. master's or higher degree. This is known as the cap. The numbers are allocated each fiscal year, and petitions can be filed 6 months in advance of the start date. For the last 15 years, USCIS has received more petitions for H-1B status than there are slots available. In the last few years, the annual quota was filled in the first week petitions could be filed. As a result, USCIS would accept petitions for 1 week and conduct a random lottery to fill the caps. Those petitions for workers with a U.S. master's degree or higher were entered into the lottery for the master's cap, and if not selected, they would be put in the general lottery.
The old system, registrations were randomly selected as in a lottery. So tell us about the new proposed system and how it's different.
Sure. The proposed rule would replace the current random selection process with a new wage-based selection process, which would prioritize the selection of H-1B registrations based on employers who pay the highest wages according to a level system.
That's the OES wage level system, the Department of Labor's wage system that has 4 wage and experience levels for every occupation.
Exactly. Level 1 corresponds to entry-level positions in each occupational category, proceeding up to level 4 for more senior and complex positions. In the proposed H-1B selection system, USCIS would sort registrations and prioritize them according to OES wage level. Level 4, the most experienced and highest wage level, registrations would have the highest priority. If the quota is not filled by level 4 registrations, it would proceed to level 3, and so on until the quota is filled. If needed, USCIS would conduct a random lottery within that wage level to give those registrants a more equal shot.
It's such a dramatic departure from the current system, and many people, myself included, think it will be extremely unlikely that level 1 registrations will be selected.
I agree.
What about positions where there's no OES wage level information, such as the occupational categories of chief executives and marketing managers? How will USCIS treat registrations that involve a private wage survey as the wage source?
Where there is no OES prevailing wage information for the position, USCIS will rank and select petitions based on the wage level that corresponds to the requirements of the proffered position. Unfortunately, the proposed rule does not define how this assessment will be conducted. Registrations involving wages obtained from non-OES sources, such as private surveys that meet the DOL requirements, will all be ranked in USCIS's selection processes as OES wage level 1.
Wow, so no matter how senior the position is and no matter how high the wages, if you're using an alternate wage source, you'll have virtually no shot at getting selected.
Indeed, that's how it appears.
Well, thank you for summarizing these very dramatic and important changes. Stay tuned to Grossman, Young, and Hammond for updates as this develops.
Thank you.